Hi everyone. Our topic is legal and ethical issues of LMHCs.
So, what are legal and ethical issues? Ethics is the branch of philosophy that investigates moral judgments and problems. In ethics, there are ethical codes, which are the set of standards or principles of professional conduct. For the LMHC trackout assumption, our ethical codes are from the AMHCA. Ethical dilemmas take place in situations where there's no one correct answer, which has its potential benefits but also its downsides. Legal psychology is the use of psychological principles and techniques in situations with criminal or civil legal systems. Legal dilemmas is where we see conflicts between ethical obligations and legal requirements, more in particularly regarding confidentiality, informed consent, and the duty to warn. So, why are ethical codes and laws important? The APA established ethical codes to help guide mental health professionals about their behavioral and moral decisions. In turn, this ensures mental health professionals are taking accountability for their actions, and it helps protect the client from harm from their therapist. Ethical codes also protect mental health counselors from the public and legal issues because there is a duty to follow these ethical codes. However, in each state, the therapist must continue to abide by federal and state laws in addition to this. Laws provide a framework where each individual can understand their rights and obligations towards others by outlining acceptable behaviors and consequences for breaking the law. Laws protect individuals living in the state or country from abuse and harm, not only from people, but also organizations and the government. Through the enforcement of laws and resolving disputes, laws create and ensure environment for economics.
There are legal responsibilities of an LMHC and there are ethical responsibilities of an LMHC. Some of the legal responsibilities include being a mandated reporter, which we'll get more into on the next slide, completing continuing education and trainings. So, as mental health counselors, there is a required number of continuing education credits and trainings that we are expected and required per our licensure to complete each year. These trainings often are related to ethics or different and new forms of therapeutic interactions. Sometimes they're about different theoretical orientations or really there are some out there that are more focused on providing some sort of supervision in a specific type of training. So whether it's like internal family systems or CBT or DBT, whatever it may be, there might be a training on how to do that therapeutic interaction followed by like a supervision opportunity. And if that were the case, then taking up the trainer on doing supervision with them would be a great way to reduce any ethical dilemmas that might come up. We also have a duty to warn as clinicians. So if we're working with a client, although in general, we're not really favorable to the idea of breaking confidentiality. If our client is for some reason sharing that they are going to harm somebody and they are serious about that, as clinicians, we have a duty to warn the person whose life or is at either literally at stake or who might be harmed by whatever our client is planning or has shared that they're going to do. And then also to aware local authorities and protect not only our client by doing that, but also the person who they're intending to harm. Um, and we are protecting our client by doing that, even though it may get your client in trouble. Your client most likely doesn't actually want to really hurt somebody. So by making it impossible for them to do that and preventing that, you're not only protecting the person who would be harmed and mitigating the risk of harm, but you're also protecting your client as well, just in a different way. And then avoiding bias. So as humans, we are innately biased to different populations or subjects or religions or whatever it may be. So avoiding working with clients who you have a bias against and also being aware of your bias. So engaging in reflective activities and talking with your supervisor, talking with colleagues, really realizing if there is a bias in your life and making sure that you're not working with clients who you have a bias against to make sure that you are fulfilling your responsibilities as a competent counselor and providing that client with the best care possible. And if you do find that you have a bias against a client or against a particular issue or a subject that arises, making sure that you're referring out. So you're referring them to a trusted colleague who doesn't share that bias and ensuring that that client is getting the best form of treatment possible for their condition. So being a mandated reporter, it is sometimes a little bit scary to think about that. Like, when do I make a report? What do I do? Who do I say? Where do I go to? And so, like Kiara had been saying, there are guidelines that are put in place to help us make these decisions and realize when it is appropriate to be making a report and when you really do need to make a report. And in some cases, your license could really depend on the fact that you are accurately executing your duty to be a mandated reporter. So, first, and what people are most probably familiar with and potentially have already had to do in the internship process is filing a 51A, which is for suspected child abuse and neglect with DCF. So, this is something that you would file when you have reasonable suspicion that a child is being abused or neglected. You can make this report without being 100% certain. Maybe you heard something that didn't sit right with you. Maybe a client shared something that was just a little bit weird and you feel uncomfortable about it. In that case, you might want to consult with a supervisor, but you also can still make that report. And as long as it is a good faith report and you truly do have a suspicion that a child is being abused or neglected, then that is the right course of action, is to make that report. The next one is elder abuse. So elderly individuals are a special population, and if you are working with a client and you suspect that there's elder abuse in some way in the home or that the client is associated with, or maybe your client is is the elder who's being abused, we have a duty to protect special populations as well. So you would file an executive order, you would file a report with the Executive Office of Elder Affairs or the local police. And on the Massachusetts websites, there's also advice to submit to both. So file the executive order of Elder Affairs, but also with the local police to make sure that you're protecting that elderly person. Abuse of a disabled person or a person with an intellectual disability. So you would file a report with the Department of Disability Services and the local police as well, to ensure that that person is being protected. Domestic violence is one of the trickier situations because there actually is no obligation to file a report unless there's a child at risk. And in most cases, you really can't file a report because this is an adult. And as long as this person is not a disabled person, an elderly person, or a child's not involved, then you really can only provide domestic violence resources and support. You can advocate for your client to go to the local police. You can support them in that process of going to the local police and getting safety. You can connect them with domestic violence shelters and resources and hotlines, but there really is not much else you can do when you're working with an adult who is able to make their own decisions, but chooses to kind of stay in the situation. And it is so tricky because in a lot of times they're not really choosing to stay in the situation. And there's a lot of factors that go into domestic violence, but these individuals, as if they're an adult who is competent to make their own decision, the most that you really should do is support them in the process of leaving that situation. But there's no legal or ethical guideline that forces you to report that. Reporting a colleague who is engaging in an ethical or legal dilemma. So you can address the coworker directly about the ethical or legal violation, but if you're not comfortable doing that, you're not required to address the coworker directly. But what you are required to do if you're aware that one of your colleagues is engaging in an ethical or legal violation is report it to your supervisor, to the agency that you work for, and also to the licensing board if there's not a mutual supervisor. So if there there is a mutual supervisor, your first step would be going to that mutual supervisor who would then take it higher up in the organization, and that's where the licensure board would be most likely made aware. But you also do, as a clinician, have the right to make a report to the licensing board yourself. And suicide and self-harm. So this is not typically legally mandated, but ethically, LMHCs should take action to protect the clients that they serve and ensure their safety. So there is a form that you can file, which is a Section 12, and it is an involuntary hospitalization form if a client is at imminent risk of hurting themselves. So if you truly feel that your client is suicidal or is going to engage in self-harm, you can file a Section 12 to force them into hospitalization. However, in a lot of cases, and this is in a lot of the different articles as well, is that the clients who are telling us that they are suicidal or that they are going to or are engaging in self-harm, they do want help, and that's why they're telling you. And so in a lot of cases, you can have them voluntarily hospitalized. But in the case that they don't want to be hospitalized, you do have the ability to involuntarily hospitalize them for their own safety if you do believe that they are at risk to themselves. So some of the ethical responsibilities of an LMHC include confidentiality, so making sure that we are abiding by the HIPAA laws, that we're not talking about our clients in parties where it's not appropriate. So really any situation outside of supervision, we're not sharing any private details about our clients, even in supervision, not like names or workplaces, things like that. Um, and that you're not sharing stories from one client to another client, such as, oh, I'm working with somebody else who's dealing with something like this. It's really not clinically relevant. And even if it is clinically relevant, it's not really fair to share one client's story to another client. Avoiding dual relationships and setting boundaries. So making sure that your clients are clear and they understand that this is a therapeutic interaction. This is not a friendship. We do not hang out outside of therapy. If you're comfortable and if your organization allows you to share phone numbers with your clients, that they're aware that that is for billing and scheduling issues, maybe some brief updates, but nothing therapeutic service related. You're not going to be engaging in therapy over text message, and also that your clients understand that text messages are not HIPAA protected. And same with emails, that the only thing that you can ensure is HIPAA protected is hopefully the telehealth platform that you're using or what's shared in person or through a medical health record type of thing. So making sure that the boundaries are clear, that you're not a crisis counselor, you're not a friend, you're not anything other than a therapist. And although you care about them, the boundary is clear and there's no room for miscommunication. And that really does protect both the client and the counselor. Providing informed consent, so making sure that your client is aware of the therapeutic practice, the therapeutic orientation, that they know the risks and limitations to outpatient therapy or inpatient therapy if that's what you're doing. Making sure that they understand your medical health record, that they understand the HIPAA laws, that they understand really some of those boundaries that we were just talking about, that they understand how to reach out for help, that you may not be reaching out to them, at different times, really just making sure that they are informed on the therapeutic practice that you are going to be engaging in with them and that their expectations are set. Competency, so ensuring that you're working with clients who you're competent working with. If it is something that you feel very unsure of, or that you're not comfortable treating, that you're referring those clients out rather than taking it kind of as a personal challenge to try to work with this client. Sometimes that's not the best course of action. Or if you are working with a client who has a disorder that you're not particularly comfortable with, that you're doing your research, that you're going to continuing education, consulting with supervisors, you're reading the articles and the evidence-based practices for that disorder, and that you are really a competent therapist. And involved in that also is cultural competency. So making sure that you're working with clients who you don't have biases towards, who you aren't expecting your client to teach you about their disorder or about their culture, that you're really taking everything in, but you're also on your own time learning what you need to learn and not expecting your client to be the educator for you. A therapeutic contract is a really great way to help mitigate some of these issues that we've talked about up till this point. So the boundaries of the therapeutic interaction, the policies that the therapist has in place. When can you text me versus when should you call the office? When can you reach out to me for support versus when should you call like 211 or 988? Like knowing the boundaries is really put clear in a therapeutic contract. And that's also probably where you would be able to provide that informed consent in the medical record, set up all of that type of information. And then assessments. So making sure that we're providing assessments for our clients throughout the therapeutic interaction, making sure that our therapy is working for the client and that we're serving a purpose, not just sitting with them and chatting every week, that we really are doing something that is evidence-based and proving to be making a change in this client's life. And then accurate billing. So we are billing what we say we are billing, that if we meet with our client for 30 minutes rather than 60 minutes, that we're changing that billing code to reflect that. If a client cancels, we're canceling that session, not billing for it anyways, ensuring that you are being compliant with the copay procedures of certain insurance companies, that you are credentialed to serve clients who have certain insurances. So billing is a huge part of being a therapist, especially in private practice, and you really want to ensure that you are billing correctly and accurately, and that that is being reflected amongst all of your clients.
Why are legal and ethical dilemmas important? So, the APA ethical codes are great, but they don't give mental health professionals explicit answers about what to do in ethical and legal dilemmas. When there are legal and ethical issues, it helps therapists to know what they should do in the same or similar legal or ethical situation. When there is an ethical or legal dilemma, ethical decision making helps the mental health professional to avoid responding impulsively or use trusting their gut as a solution. So, this way, therapists can avoid fast, instinctive, and emotional decisions that contains personal biases and blind spots. So, there are different models and steps to the decision making process, but I found these steps are found in most of them. So, define what the problem is. What are the facts and details? Start to consider some ethical issues. Think about who's being impacted, what the issues could do because of the impact. Look at your organization's regulations, your affiliated group's code of ethics, so either the ACA or the AMHCA, or in some states, they do follow both. And then we need to look at what are the state and federal laws, and also consult with a lawyer. In the code of ethics, you're supposed to make decisions similar to your colleagues, so it's advised you speak with your colleagues or other supervisors because honestly, two minds are better than one. So then we need to generate some possible solutions to what your issue is. So consider some possible outcomes for each solution you formulated, and then choose the best decision and continue monitoring the decision. You can modify your decision as time goes on. And lastly, legal and ethical dilemmas help you to learn from other people's mistakes and ethical decisions. All right, now we are going into some ethical issues. An LMHC is treating a client who's involved in a legal proceeding. The client presents the LMHC with information about a well-known local psychologist who released confidential information to an attorney without a signed release or court order. After the LMHC reviews the information presented, it's clear the psychologist breached confidentiality. The LMHC knows the psychologist but does not have a strong relationship with them. So, what would you do? Would you address the matter with the psychologist directly? Would you report the matter to the state licensing board of psychologists? Would you encourage your client to file a complaint with the state licensing board of psychologists? Or would you do something else? Here's what we recommend. So, in this case, it's important to understand that this is a break of confidentiality. So, HIPAA has been broken, which is a federal law. So under the AMHCA Code of Ethics, we are required to take appropriate action when we know there is an ethical violation. So first, we need to tell a colleague or supervisor about the situation. So we want another opinion. Then we document everything. So, what was told to you? Who told you? And what are you doing about it? If you want to keep good ties with the psychologist, do inform them that they're being reported on. However, if you don't think it's a good idea to report them, then don't inform them. And lastly, try to make sure that your client's identity is not disclosed. So here's another legal and ethical dilemma. So an LMHC receives a letter from an attorney indicating that they have inherited an old antique from Sarah Palmer. The LMHC recalls they treated Mrs. Palmer a number of years ago. Looking through their files, they were terminated 7 years ago. The LMHC calls the attorney and discovers Mrs. Palmer left a mid 20th century duck decoy. No one contested the will, and the LMHC researched that the duck decoy is estimated to be about 50,000 or more. So the LMHC can't remember many details about the client. They remember that they're an elderly woman who had significant depression, but eventually, with therapy, they were able to improve. But besides that, nothing unusual stands out about the therapeutic relationship. So, what do you think? Maybe you said, I'm going to accept that antique. Or maybe you're like, maybe I'll look for some other family members to receive it. Or maybe you just said, nope, don't want this issue. I'm just going to decline the antique. Maybe you decided something else. This is what we recommend. So, first, consult with an attorney familiar with mental health ethics and other colleagues or the ethics board themselves. Make sure you're documenting all of your actions and then consider declining the inheritance. I know it's a lot of money, but this is why we're suggesting it. Due to the amount, it does raise some red flags about blurred boundaries. It has been 7 years, so that decreases the concern about exploitation. But since it's with a former client who has made this decision when they might have been vulnerable, it warrants caution. Even if you got it legally approved by the ethics board or your lawyer, the value may damage the trust the public has with the LMHC. So we suggest maybe the funds be directed to the client's memory or assisting research for treatment for the client's disorder. So here's another legal and ethical dilemma. An LMHC has been working with a woman for several months who has depression, anxiety, and relationship issues. During one of the sessions, she indicated her boyfriend had lost interest in sex and became more involved with online pornography. While discussing the issue, the client stopped talking and said she was hesitant to speak about the issue in fear of breach of confidentiality. The LMHC reminded the client about confidentiality laws in Massachusetts that would override it. The client informed the LMHC during a heated discussion the client's boyfriend said watching pornography was not as bad as what his uncle did. The client disclosed the uncle is involved in collecting and distributing child pornography but remains faithful to his wife. The client asked the LMHC if she could give the information. The client asked the LMHC if she could give her the information to report it to the authorities and leave her out of the situation. So, what would you do? You say consult with other colleagues, supervisor, or lawyer, and then file 51A. Did you say focus on assisting the client manage the situation and you're just going to avoid this whole entire thing legally overall? Or did you say maybe suggest to the client they should contact DCF anonymously? Or maybe you said something else. So here's what we recommend. So consult with an attorney that's familiar with mental health ethics or other colleagues or the ethics board themselves. Make sure you're documenting all of your actions, all of your recommendations, what was disclosed, and the client's request to stay anonymous. You can contact DCF anonymously for pre-report guidance in this situation, but due to the case, you will have to file 51A. So you need to make sure you're informing the client beforehand about your legal obligations, what you're going to do, and that you're going to try to only disclose what's necessary.
So, in addition to the existing legal and ethical dilemmas that we've talked about in this presentation, but also throughout the course of this entire program, we've explored different existing legal and ethical dilemmas. There are emerging ethical issues as well. So, similarly to the way that therapeutic practices evolve and change over time, ethical issues evolve and change as well. Some of the emerging ethical issues for LMHCs include telehealth and privacy concerns, the use of AI in mental health tools, and social media and therapist self-disclosure. Keeping up on your continuing education and making sure that you're taking a variety of different continuing education, like we had mentioned before. So some relating to ethics, some relating to, legal issues for LMHCs, and then some that are relating to different therapeutic practices, and maybe also some relating to your own theoretical orientation as well, so that you're kind of getting this really versatile experience of continuing education, and ethical and moral dilemmas will come up along the way in continuing education. So making sure that you're engaging in supervision in continuing education will help you stay up to date on what the emerging issues and ethics are. And in this day and age, they're evolving rapidly, especially with the use of AI. I personally have heard lots of stories about people who are referred to use AI by their own therapist, like talking to AI when therapists aren't available, or I've heard of therapists using AI to write notes for them and all sorts of different issues. So making sure that we're staying up to date on ethical issues related to being a counselor, and also staying up to date on the results of those ethical dilemmas and issues that have come up as well, so that we can learn from other colleagues, like Kiara had mentioned. So now we are going to go into another scenario about an emerging issue in ethics, which is the use of AI. In an effort to streamline her practice, an LMHC in Massachusetts begins using a third-party AI-powered chatbot to conduct initial intake interviews and provide emotional support between sessions. She informs clients in her consent form that digital tools may be used, but does not specify or explain how the AI functions, or that it may store and analyze sensitive data. After several months, a client discovers that the AI service stores transcripts on external servers and potentially uses the data to train its algorithms. The client feels betrayed and files a complaint, claiming a violation of confidentiality and lack of informed consent. So in this case, the AI was being used to conduct intake interviews as well as providing communication in between sessions. So the chatbot is aware of names, demographic information, intake information. So really a lot of personal and sensitive data was being collected by this chatbot. So why? It's because it's easier. It's easier for the clinicians. Clinicians using AI are able to get more done quickly. They're able to think less about each particular client. So is this an issue in ethics? It definitely is, and it's being explored and studied more. So which of the following ethical principles from the Code of Ethics are directly violated in this scenario? So fidelity and responsibility, beneficence and non-maleficence, integrity, privacy and confidentiality, or all of the above. So if you said all of the above, you'd be correct. Fidelity and responsibility, it really emphasizes the trust between the clinician and the client, and it's the clinician's responsibility to meet professional and ethical standards. So the LMHC in this scenario delegated a large portion of her work during a vulnerable stage of therapy to AI without adequate oversight or warning, failing to honor the trust of the therapeutic bond. The use of AI being used by the LMHC states that it is collecting data. With the recent introduction of AI, we are not 100% sure that the LMHC is actively that the LMHC is actively doing good and avoiding harm. The use of AI may cause clients to feel violated, anxious, or uncomfortable if they were to find out the full extent of the AI in this scenario. Integrity. So the LMHC in this scenario was not fully transparent with her clients in relation to how AI would be used in the therapeutic process or what extent AI would have access to private information. And then most clearly violated is privacy and confidentiality. So the use of the AI chatbot collecting client data, including demographic information. The chatbot is not HIPAA compliant, and the client's information is going to be used for further development of AI. So all of the principles were violated in this scenario. The next emerging and ethical dilemma is social media. So, an LMHC in Massachusetts runs a popular TikTok account focused on health and wellness. She provides psychoeducation and personal reflections about managing mental illness. The LMHC often posts day in the life content, personal stories of trauma and anxiety, and information about her personal life mixed in here and there. The LMHC is part of the Creator Fund and is paid for her views and interactions. The LMHC values her following and often engages in vulnerable and personal public replies to followers' comments. Over time, her popularity on social media has grown and she's lost track of her 300,000 plus followers. It is likely that her followers not only include members of the general public, but also former clients and current clients. Although the LMHC is not directly or intentionally violating a specific ethical guidelines, what ethical concerns are raised? So some of the possible ethical concerns would be in multiple relationships. So it could be confusing for clients to view their therapist as an influencer in person, but also at home. So in practice, but when they're at home too, watching videos, they maybe have a higher likelihood to become obsessed with their therapist or want to be just like their therapist. Personal problems and conflicts. So clients may feel pressured to take care of their therapist, knowing her trauma history and information from her day in the life videos. Maintaining confidentiality. Comments from former or current clients may expose possible therapeutic relationships and bonds, and fees and financial arrangements. So, therapist is being paid by the Creator Fund to interact with possible clients. So, kind of a double dipping situation here, where clients aren't fully aware of it. Also, the therapist could potentially be engaging in advertising opportunities on TikTok that would more easily influence former or current clients to purchase whatever she's selling, especially if that multiple relationship thing is happening where clients feel like they're friends, but also they're holding their therapist to this really high influencer standard. And also, it's their therapist having a direct input on their life. So, lots of different gray areas here that we identified while reading the Code of Ethics. And we were even reading some of them and we're like, well, yeah, kind of that too. So, having social media as a therapist is a tricky thing to navigate, especially if you are in the influencer realm of social media. And then telehealth. So the use of telehealth for therapeutic services has become widely accepted among mental health professionals since the COVID-19 pandemic. In the beginning, clinicians were very cautious and nervous using telehealth for therapeutic interactions, but in most cases, it was better than providing nothing during COVID. With its growing popularity and convenience and its acceptability by health insurance companies, we must remember the possible ethical concerns that may arise when we become complacent. So, for example, just hopping on a phone call with a client, but you're in the grocery store, things like that, we need to consider. So, what are questions to consider before just hopping on a telehealth call? The first would be, am I using HIPAA compliant software? So Zoom, the unpaid version of Zoom, FaceTime, those types of platforms are not HIPAA compliant. So making sure that you're using something that is. Are you using secure Wi-Fi or are you on a public Wi-Fi? Are my clients aware of the risks and limitations of telehealth therapy? And did I provide specific informed consent for that? Am I in a private space where others cannot hear either side of my discussion with my client? And is my client in a private space where they feel comfortable to share and talk? Because you really can't see what's around them besides directly behind them. And is my client in a state where I'm licensed to provide therapeutic services? It's important to ask that question because if your client is in Connecticut and you're not licensed in Connecticut, but you're in Massachusetts, and typically your client comes to see you in Massachusetts, you should not be providing telehealth therapy with them. So you really should be doing the responsible thing by making sure that your client is in a state where you're licensed to provide services. And are the boundaries clear? Is your client aware that they can't just FaceTime you every time that they want to talk? Do they know um, what boundaries are set when you're doing telehealth visits, that it can't be used to like cancel last minute, anything along those lines. And then professional guidelines that prevent ethical dilemmas and situations. So the APA is an organization that provides resources for clinicians in regard to ethics. The APA has an ethics committee that can help clinicians and clients in particularly challenging ethical dilemmas. The APA also has an ethical code and an ethical or a code of ethics that you can refer to, as well as your state's code of ethics. So each state has a code of ethics that you can refer to as well. We've referred to the Massachusetts one a lot here, and making sure that when you're referring to them, you're looking at the clear and straightforward ethical standards and guidelines, and that you're following them as well. Supervision, so direct oversight and mentorship, holds clinicians responsible and helps clinicians reflect on possible ethical dilemmas. It is often provided by experienced and seasoned clinicians with years of experience. And then engaging in that continuing education, going to trainings that ensure that you're up to date on the best practices and ethical hurdles, and that you are having a wide variety of trainings, not just clinical-based trainings, but also ethical and legal-based trainings as well. And these are our references. Thank you.